Good evening to everybody. Welcome to the today class. Yesterday that I dealt the trespass to land. Some of the thing which I completed, at least half of them, half of it. The rest of the half today in this class, I would like to complete. Please read what I posted on the screen. Yes, unmute and read. Read what you
Good
posted
evening.
on the screen.
Good evening. Namaskar. Salam alaikum. Trespass. Professor Dr. Mohammed Saheb Hussain, sir.
What is this? Could you see? What do you call this one?
Don't pass on, sir.
Barbed wire. It is called
Barbed
barbed wire. Yes. And this is also the trespass, no trespassing in the say in the garden, and it's a land, so trespass to land it is also. But before the other people will join, let me ask you this thing. These are all the. Could you see this? Could you see it on the screen?
Yes, sir.
What are they?
Tiger.
Here also.
Tiger, sir.
Yes. Could you find it out? Which is the female tiger and a male tiger?
No, sir.
So a female tiger, generally say male tigers are usually bigger than the females. They have the longer tail and a bigger paws. A tiger with a cub is most likely to be a female, as a male tiger don't help raise their children, means young. Tigers are not social animals and usually hunt alone. So in this one, can you tell me which one is the male, which one is the female?
Left one is the female, sir. Right one male.
Yes. What over here?
Right
Same.
male, left female. Same.
Yes, because in the say the hefty personality is there, and the pass. If you see the pass, it's a bigger. So that is a this is a male tiger. Then what do you call the female tiger? The male tiger is called tiger, masculine gender. What is the feminine gender?
Tigress, sir.
Tigress. So that is so let us come to our class. Yesterday that I was dealing with the section 52 Indian Easement Act of 1882 defines license. I read this. I quote, where one person grants to another or to a definite number of other persons a right to do or continue to do or in a upon a immovable property of the grantor something which would in the absence of such right be unlawful, and such right does not amount to an easement or an interest in the property, the right is called license. That is about the license. So after the license is revoked, like the license means if you buy a ticket and go to a movie, it is a license. If you buy a ticket, go to a circus, it is a license. So you can stay over there up to the period is over, means show is over. But you cannot be there beyond the show. If you stay beyond the show, then you will become a trespasser. So after the license is revoked, the licensee becomes a trespasser on land and must quit the place within a reasonable time. For the purpose of the right of the licensor to revoke the license are considered to be two kinds. There are two kinds of the license are there. Number one, a bare license, and second, a license coupled with a grant. And let us see what is a bare license can be revoked. A bare license can be revoked, where a license which is coupled with the grant cannot be revoked. So a license to see a picture is a license coupled with a grant. A license to see the circus is coupled with a grant. A license to cut the tree is coupled with the grant to take the timber. Are you following me?
Yes, sir.
Similarly, a license to cut down a tree and carry it away in an example of license coupled with a grant, the timber. In certain cases, licensor, by the terms of the contract, express or implied, may agree that even a bare license will also not be revoked. But generally, this is a Wood versus Leadbitter case law. They revoked the license. Actually, it is not a good way, because once the license is given, you are not supposed to revoke, because that is the reason it became obsolete. And now nobody is following the Wood versus Leadbitter case law. Let us see what is the wood versus better case law. Let better case law. Just unmute and read this case law. Anyone? Read this case law.
In Wood versus Leadbitter, the plaintiff, having purchased a ticket, went to see a horse race, and the defendants were the occupants of the race course. While the races were still going on, the defendants asked the plaintiff to leave the premises, and on his refusal to comply with Matt, he was forcibly ejected by the defendant's servant. The plaintiff brought an action for assault. It was held that the revocation of the license was effectual, and after the revocation of the license, the plaintiff had become a trespasser, and ejection of the trespasser out of the premises was not an actionable wrong. Obsolete now.
Now it is an obsolete because here the license is given to see the race course. Okay. While the race course is still going on, the defendant asked the plaintiff who purchased the ticket to leave the premises. And on this refusal to comply with the match, and he was forcibly ejected by the defendant servants. The plaintiff brought an action for the assault, but it was held that the revocation of the license was effectual after the revocation of the license. So the plaintiff had become a trespasser, and ejection of the trespasser out of the premises was not an actionable wrong. But one thing is very much clear over there. Perhaps he might have created a nuisance over there, number one. Number two, he might have returned the amount which is paid to him. Otherwise, once the license is given, they don't revoke it. Suppose if you go to a cinema, of course, at that time there will not be any, generator. And the cinema, when the power goes, the cinema will be stopped. When the power comes, the cinema will be run. Are you following me?
Yes, sir.
So, suppose if the cinema just be about to start, trial is over, they are going to make the start of the cinema, the power has gone. The power did not come at least for the 2 hours. Then what the cinema owner does, he will say that whenever the power comes, if you want to see the movie, okay, you can continue it. If not, he will return the ticket. I mean, he will give the money back to you. Are you following me?
Yes, sir.
But nowadays, the generators are there. If the power goes, of course, automatically generator will start. And there is no question of returning the money. There is no question of, even you feel that the power is off. Is it clear?
Yes, sir.
So now let us see the another case law, Hearst versus Picture Theatre Limited case law. It is just to opposite the effect of this Wood versus Leadbitter case law. So the plaintiff, after the payment, purchased a ticket to see a cinema show at the defendant's theater. He was wrongly suspected of having entered without a ticket and was asked by the
Sir,
manager
your
to
voice
leave
is
the hall.
breaking, sir.
Yeah. Because when the power is, the fluctuation would be there, naturally at the time it will break. Otherwise, it will be quite good. Because when the recording, there would not be any break of the voice. The reason is there is something wrong from your side. So let us come to the point here. As you read it, I could know that whether your mobile data is weak or your mobile data is strong. Read this case law. Read this case law. Read this case law. Anyone?
The decision in Hearst versus Picture Theatres Limited is just to the opposite effect. The plaintiff, after due payment, purchased a ticket to see a cinema show at the defendant's theater, was wrongly suspected of having entered without a ticket and was asked by the management to leave the hall. On his refusal to do that, the defendant's gatekeeper physically lifted him out of his seat, and the plaintiff himself quickly walked out of the cinema hall. The plaintiff then sued for assault and false imprisonment. The license to the plaintiff in this case was considered to be with a grant, and it was held that the same could not be revoked.
The revocation being invalid. The plaintiff was not a trespasser to the defendant's premises. As such, he was held entitled to recover the substantial compensation from the defendant for the assault. Here, in this case law, it is a grant with it is a license with the grant. In the Hearst versus Picture Theatre, how could he suspect that he doesn't have the ticket? Because generally, the ticket will be issued depending the capacity of the seats. Are you following me?
Yes, sir.
So there is no question of such a chance that he is the suspect doesn't have the ticket. So he was not being lifted out. When he is lifted out, means an assault was done, and at the time he will file a case. Yes, they say he is entitled to get the compensation because the Wood versus Leadbetter case law, there is merely a license, but this case law is license with the grant. What the grant? They are supposed to stay over there till the Picture is over. So Wood versus Leadbetter was an authority for the rule that the license coupled with the grant was not recoverable. This was considered to be grant Wood's case for some other reason. So here they want to say is the Woods and versus Leadbetter case law is the obsolete case law. Now any license you should go with the grant. So the decision in the Hearst case has been formally approved by the House of Lords in Winter Garden Theatre Limited versus Millennium Products Limited. So Winter Garden Theatre Limited, what is the mistake here? What is the mistake here?
వింటర్ గార్డెన్ థియేటర్ అనేది మిస్టేక్.
Limited తర్వాత full stop ఉండాలా, comma ఉండద్దు, because it is an abbreviation. Any abbreviation ends with the full stop. Of course, shortening it is. It's not strictly speaking, it is a shortening. So any shortening, first letter should be the capital letter, and the rest of the letter should be the small letter, and then ends with the full stop. So Millennium Production Limited, CLTD full stop. So that was the mistake. So Hearst case has been criticized on the ground that damage would have been adequate remedy, no order of the specific ones would have been issued. So here the point is, damages should be awarded over there. In sometimes damages are not necessary. A specific performance should be there because allow him to see the movie. Are you following me?
Yes, sir.
So now let us see the trespass by relations. What the relations are there? One has the right to possess by legal fiction deemed that when he entered have been in a position from a moment with the right of entry accrued. Thus, if an owner of the property, here owner of the property, wrongfully used a position managed to enter his premises, he will be doomed to have in any position even during the period that is actually out of the position, and he can bring an action for the trespass for the wrong the property during that period. Suppose if you are given the lease period would be there. If the lease period is over, then he is having every right to enter into the land because he is having the reversionary right. At the time, he will not call a trespasser because trespasser by relations. Here, the relation is he is the owner of the property. So actual physical contact is not necessary to constitute the de facto position. That is the position in fact. Books are close or home, not a sea or a railway train. See, if anything would be there, it is in your position. You are the owner of the property. Of course, you are owner of the property means you have every right to not to allow the other person because the position is 100% ownership. The finder of the goods is the owner of the goods unless until the owner will be traced out. So here the relationship is ownership is more important, not important. Possession is more important. So that is what I want to say. Are you following me?
Yes, sir.
So trespass over airspace. Here over airspace also, a person has an ownership of not only the air surface, but also anything below the subsoil or above the space, airspace. The surface which is capable of being reduced into the private ownership, unless until if the surface is reduced to the private ownership. In India, the Aircraft Act of 1934 make it a punishable offense for any person willfully to fly an aircraft to cause a danger to any person or property in land or water in the air, but it contains no provision of absolute liability as in the English Acts. Suppose if the aeroplane goes very low, below less area, at that instance you got the nuisance and you will feel your house's kitchen articles will be rattled and it will vibrate and there is a nuisance caused in the night. So naturally the flights would be, when they fly with a minimum height would be there, then you can fly over there. But especially at the time of the taking off or the landing, naturally they will come down. At that instance, the adjacent area, which is adjacent to the runway, there would not be any multi-story buildings. So the landowner has the right to the airspace above the surface and infinitum. The ordinary rule is that whoever has the solum, whoever has the site, is the owner of all up to the sky, down to the earth's center. In modern times, the owner has the right to air and space above his land is limited to the height required for the ordinary use and enjoyment of land. So how much height you can enjoy it? Only to a certain extent only. Because beyond that height, it is you are not the owner of the property. Of course, if any thing which goes beyond a particular limit, then it cannot be a trespass on the surface of your land, on the airspace of your land. So let us see the Kelson versus Imperial Tobacco Company Limited. In this case law, an advertising sign erected by the defendant over the plaintiff's single-story shop projected into the airspace. So advertisement is protruded to the adjacent shop and in the airspace in the upper part. The defendant argued that the super incumbent airspace invasion was not a trespass. The airspace, when something is protruded, the advertisement, it is not a trespass, but a nuisance alone. That was the contention of the defendant. But the plaintiff said the projection into the airspace of the plaintiff was held to be the trespass only, not mere a nuisance, and a mandated injunction was granted over there. It is not a nuisance, it is a trespass itself, because either treading on the land surface is a trespass, or below the subsoil is a trespass, or above the airspace is also a
Trespass.
trespass. It's not a nuisance. When it becomes a nuisance, you tell me. Suppose if your dilapidated chimney falls down and the bricks reaches to your adjacent land and touches its property, then it can become a nuisance. But if you throw a stone on somebody's land, it's not a nuisance. It is a trespass. Either you personally you go over there and stand in his land, or you throw a stone on his land. In the both the way, it is a trespass. It is not a nuisance. What is a nuisance? Of course, when the smoke always comes and it disturbs you, at that time the enjoyment, that may be a nuisance. But continuously, if you are burning it from morning till evening, in the night also, then it is not a nuisance, it is a trespass. Are you following me?
Yes, sir.
A little difference would be there in that nuisance and trespass. I will give the distinction. Let us see the Branston versus Skyviews. When Branston sued the defendant in trespass for taking an aerial photograph, and from 100 of meters above the ground of his house, the issue of the trespass into the air above the ground was in a question. Suppose somebody is taking bath and that bathroom doesn't have the ceiling. Somebody take from the photo from the high distance. Whether it amount to a trespass is a question. Aerial. If the intention that fellow is taking the photograph of the open bathroom, that means that fellow is want to enjoy the nude figure. Are you following me?
Yes, sir.
Yes, sir.
So the person who enjoy to see and enjoy, it's called voyeurism. That will say voyeurism. Because he is changing the dress, he will enjoy it. And there is a very good case law is there. I don't know whether you could remember the case law in the Goa. Because that is in the trial room, they kept the CCTV in the trial room. And the women goes over there, the CCTV, they could enjoy it. They're changing the dress. So one lady is there, she is a IAS officer, that I am saying, Irani. That is, his name is Savitri Irani or Sami Irani. She filed a case against that owner of the mall. And the case said, yes, you are not supposed to say it is the privacy you are taking away, and he will be punished under the IPC, because in the IPC the voyeurism is there. Yes, it is a offense. Smriti Irani, that is the case law. Smriti Irani case law in the Goa. So now the court held that the height of Branston had no reasonable use of the airspace and the defendant was not liable for the trespass on the ground. Suppose the aerial photograph, if you take it, it is not amount to a trespass. But if you take a photograph when the bathroom doesn't have the ceiling, yes, that is the amount to be the crime. Is it clear?
Yes, sir.
So that is the continuing trespass. What is the continuing trespass? Every continuous trespass is a fresh trespass. Because unless until you remove the object from it, then it is a trespass only. in the respect of which a new cause of action arises from day to day along the trespass continues. So if you treat somebody's land daily, it is a fresh trespass. Today, one trespass. Tomorrow, another trespass. Day after tomorrow, another trespass. So continuous trespass is a fresh trespass. Now let us see the difference between the trespass and nuisance. In trespass, by the nature of the injury, if the injury is direct, then it is a trespass. Direct injury is there, it is a trespass. If the injury is consequential, then it is a nuisance. Like the heavy wind taking away the smoke towards your house, it is a consequential. So it is a nuisance. The trespass is actionable per se. What is an actionable per se? Anyone? What is meant by actionable per se?
Pass on, sir.
You need not to prove there is a damage is happened. Is it clear?
Yes, sir.
If you just put your leg on somebody's land without his consent, it is the actionable per se. Even though there is no injury at all. And there is no harm is caused over there. No. Trespass is actionable per se. Need not to show there is a damage is caused over there or proved over there. But nuisance is actionable only on proof of damage. Nuisance, it's not an actionable per se. But your damages, you have to say that because of your smoke, I got the asthma. Because of your smoke and dust, my rose garden is value is lowered. Nobody is purchasing it because the smoke is falling over there. The roses become a dark roses or black roses. Are you following me?
Yes, sir.
A substantial damage should be seen in the nuisance. But in the trespass, no. If you give a flying kiss, even though nothing is going to happen, it is an actionable per se. Because the indecent sign. So trespass describes the prohibited conduct. Yes, one should not supposed to do. But a nuisance describes the type of harm that is suffered. Because you cannot run or play your music system the entire 24 hours. Because that causes a nuisance to the people those who are sleeping. And if your volume is high, the fellow is having the heart attack, he will die on the spot. So trespass requires a direct entry into the property of the plaintiff, yes. But nuisance is not indirect, consequential, can take place from outside the property of the plaintiff. A person only in the direct position, including the tenant of a land, can sue. So a person in the position of he can sue in the trespass. A person who is indirectly affected may sue. Even indirectly affected may also sue because ownership is not the count here. So illustration, throwing a stone on the neighbor's land is a trespass. Here, if the roots of a tree planted on the defendant's land undermine the foundation of the neighbor building, then it is a nuisance. So what is protruding on the defendant's land? Anyone? What is protruding on the defendant's land here?
Nuisance.
Branches and roots. Branches and
Root.
see, if the roots of the tree planted on the defendant's land undermine the foundation of the neighbors, means what is the undermine the foundation of the neighbors? The roots pekilistayi, pekilinchadam antaru the foundation. It makes the crack in the foundation. The undermine the foundation of the neighbor means building. Then it is a nuisance. What it pekilistayi, roots will, what will done? Makes the cracks in the foundation wall. What about the branches? The branches protruded and there would be a lot of dry leaves fall over there. If the branches of the mango tree is there, there's no problem at all. Am I getting? Did you get me?
Yes, sir.
The branches of the guava tree is there, there's no matter at all. If the branches of the orange tree protruded your land, there is no problem at all. But if any other tree, like a neem tree branches are there, then the leaves will fall and the neem fruits also fall and there is a lot of mosquitoes and flies will be gathered over there. So it becomes a nuisance. So defense to the trespass. What are the defenses available? Any justifiable entry or interfere with the negative liability for the trespass. Justification with the law. One is the private defense. Another is a notable accident. Another is a license. Another is a necessity. Another is a parental authority. These are all recognized lawful defenses for the trespass. In the necessity, I told you two cases where a fire brigade comes over there, and if you went to extinguish the fire, and you will call a trespasser. It is not necessity. Can you tell me the name of the case law?
Pass on, sir.
Carter versus Thomas. But another case law is there. The fire brigade did not come, and he went over there and rescued the material, and there he will not called a trespasser because of the necessity. What is the name of the case law? You
Pass
have
on,
to
sir.
remember, otherwise, no tort law,
No case law.
no case law, no tort law. I told you several times. What is that? No?
No case law, no tort law.
You go, చూసారా? Tort
Yes,
law
sir.
is nothing but a product of case laws. Tort law is a multiplication of the case laws. No case laws, no tort law. సార్ మీరు కొడుతున్నారా సార్ నిజంగానే చెప్పిండ్రా సార్? Let us see why you are worrying. Let us make it out. Oh, here he is not giving the gap. See, one case law, what I told you, Thomas, the Cope versus Sharp is no trespass. It is a no trespass. In Cope versus Sharpe, the defendant entered the plaintiff's premises to stop the spread of the fire in the adjoining land where the defendant's masters had the shooting right. Since the defendant act was to prevent a greater harm, he was not held liable for the trespass. What is the name of the case law?
Cope versus Sharp.
Then we will see the Carter versus Thomas. General defenses. ఇక్కడ చూసినా మనం జనరల్ డిఫెన్స్ లో వచ్చేసాం. కార్టర్ వర్సెస్ థామస్ కేసులో ఇక్కడ వచ్చేస్తుంది మనకు నెసెసిటీలో. వాట్ ఈస్ దట్ ఇట్ సేస్? నెసెసిటీ. ఇన్ ద నెసెసిటీ ఇట్ విల్ కమ్ ఓవర్ దేర్. ప్లెంటిఫ్ రాంగ్ డోయర్, ఇన్విటబుల్ యాక్సిడెంట్, దెన్ నెసెసిటీ. పద్మావతి వర్సెస్ గుద్దగానే, దెన్ రావలింగ్ నికోలాస్, కల్లులాల్ ప్రైవేట్ డిఫెన్స్, పడ వర్సెస్ హార్బోక్ మిస్టేక్, నెసెసిటీ. వచ్చిందా అండి?
Yes, sir.
Versus Thomas. Read the case law. Read the case law.
In the case of Carter versus Thomas, the defendant who entered the plaintiff's land premises in good faith to extinguish the fire at which the fire extinguishing workmen were already working was held guilty of the offense of trespass.
Here is a trespass. Carter versus Thomas, because fire brigade is already there, and hence he is a trespasser. But Cope versus Sharp, the defendant entered the plaintiff because the fire brigade is not there, then it is a necessity. So that is the way to remember the things. Is it clear?
Yes, sir.
Yes. Now let us see that necessity. The following defenses are available for the defense for the trespass. Exercise of the easement and prescription. Easement ఉన్నదండి. Suppose if you are having the multi-story building, very adjacent to the multi-story pillar, you are not supposed to dig the well because your land supports my pillar needs it. It's called easement. Your land supports my pillar needs it. Hence, you are not supposed to dig the well or any trench very adjacent to the pillar, load-bearing pillar adjacent. That is called easement. Come to the prescription is concerned. Suppose if you are parking your car more than 20 years without any disturbance, without any quarrel, that means you have every right to park your car in that particular place because you enjoyed it, and the doctrine of prescription will come, which is more than 20 years. Of course, it depends upon the years. Country. Some country 7 years, some country 12 years, some country 20. But in our India, I believe it's a 20. Leave and license. So when you have the license, yes, you can be there in the circus. But morning show circus, your ticket you purchased. First show you want to see and second show you want to see, you cannot supposed to stop over there. Otherwise, you will become a trespasser, even though you are licensee for the show. So once the license is revoked over there, you have to leave the premises. And the act of necessity, just now I told you, the two cases, Carter versus Thomas, when the fire brigade is there, you are not supposed to be there, otherwise you will be called as a trespasser. If the fire brigade did not come, Cope versus Sharp, yes, you are not a trespasser. The authority of law, that is the statutory authority. And we read the statutory authority, general defenses. Tuff versus Whale Company, the railway company. And Smith versus London, what is that? Smith versus London Company. There is we can write the Smith cases law. Why we can see over here? Statutory authority, see. Wagon versus Tuff Whale Railway Company. You can cite this
Smith
case law.
versus London and Southwest Railway.
Smith versus London and Southwestern Railway Company. See, remember this. Smith versus London and Southwestern Railway Company. It is a negligence on the part of the railway company. It is not a statutory authority because the hedges which you cut between the rails were becoming hay, and this hay is ignited with the chimney falling of the live coal and is carried over the by the air and burn the plaintiff's land or property. So it is the negligence on the part of it, the railway, hence is not a statutory authority. That you have to say it. And the absolute authority, there is the Metropolitan Asylum versus District versus Hill, there is the Metropolitan Authority would be there, where you can use that case laws. So re-entry on land. Suppose if you are given the lease period is over, then the owner is having the every right to re-enter in the land. It is the extrajudicial remedy. You need not to go to the court. Are you following me? Say yes.
Yes, sir.
So retaking of the goods. Suppose if you are lent your pen to somebody else, or you are lent the land to somebody else, or your chattels to somebody else, means pet animals or livestock, chattels, then you do have every right to take it back. And abating nuisance. Suppose somebody's land, the trees, branches protruded on your land, or the roots which were cracked your foundation of your building. So you do have every right to abate, means remove. Abate means remove. You have every right to say yes,
Remove.
or pass on. Suppose somebody's land, branches protruded in your land, and the roots entered into your premises and made the crack to the building of your foundation of your building. Then you do have every right to
Cut those branches.
Yes, cut the roots. That is called abatement, means removing, because that is a trespass or nuisance.
That is a nuisance.
That is a nuisance because it is indirectly, consequentially it came, not direct. So hence we can say nuisance, evading the nuisance. And remedies, re-entry. Yes, one can have a right to enter into the premises because once the lease period is over. So Hemming versus Stoke Pages Golf Club, the plaintiff had been the employment of the defendant. On the termination of the service, the plaintiff was given a proper notice to quit the house. On his refusal to do so, the defendant, by the use of reasonable force, themselves entered those premises and removed the plaintiff and his furniture out of it. The defendant were held not liable. Because once your services are terminated over there in the golf, you are not supposed to enter into the same premises because you are a trespasser. Is it clear?
Yes, sir.
Action for ejectment. Section 6 of the Specific Relief Act 1963 gives a speedy remedy to a person who has been disposed of the immobile property otherwise than the due course of law. Suppose if the lease period is over, you are supposed to evict it. So that is the action for ejectment, means you can have every right to that fellow to remove from the premises, eject him from the premises. So this is a speedy remedy where the person who had been disposed of a certain immobile property without due course of law can recover back the property without establishing any title. He need not to make it out because if the lease period is over, you should have to evacuate it. So that is why you will give the rent of the houses only 11 months. Of course, for business, we give the 3 years, 5 years. But for the longer time, we can give the 100 years also lease. Are you following me? Lakaran Cheru lease, how many years? In Khammam, 100 years lease that is. So the section gives the relief only to the person lawful position. And if anybody in Tanzania, you will say that there is a market is there, that is mall of the South Africa. They kept the mall. So the premises is leased for 100 years. The premises belong to the University of Dar es Salaam because it's having a very long premises. A big premises will be there. They have given to this South African company all the malls for the 100 years. So they constructed at least 2 or 3 very big halls and running the malls, and there is a very good a theater would be there for the conferences, and the staff, those who are working over there, they are having the staff quarters also in that premises because it is given for the 100 years lease by the UDSM to the South African mall company. Mall means supermarket. Okay. This section gives a relief only to a person lawful position. A mere trespasser cannot have the recourse of the provision. Action for the mesne profit. This is section 2, subsection 12 of the CPC. What is the mesne profit? Because that fellow did not vacate it. He enjoying the premises and he is raising the crops. Till he will be ejected water, whatever the profit he enjoyed it. And that profit, half of the amount should be given to the owner of it. That is called a mesne profit. Apart from the right of recovery of land by getting the trespasser ejected, it will take at least 1 year or 6 months or 3 months to eject him. A person who was wrongfully disposed of his land may also claim compensation for loss which has suffered during the period of disposition. Mesne profit is referred to the profits taken by the defendant during the period of his occupancy. Whatever the period of the illegal occupancy would be there, meanwhile that he enjoyed harvest, then the half of the harvest should be given to the owner of the property because unless he enriched himself at the cost of others. So equity principle will work over there. Nobody could enrich himself at the cost of the others. Equity principle. So an action to recover such a compensation is known as an action for the mesne profits. And if the plaintiff likes, he may sue the ejectment and the mesne profits in the same action. Yes, because he enjoyed the property. So both the thing, ejectment as well as the mesne profit, he can file it to the plaintiff because the defendant illegally occupied it and harvested till there 3 months to the 4 months till the harvest is over. Later on, he is evacuated it. So mesne profit also he can enjoy. Sir, Banjar Dod ante telusa andi meeku?
తెలుసు సార్.
బంజరు దొడ్లు ఎప్పుడు కట్టేస్తారండి?
బర్లను
ఎందుకు కట్టేస్తారండి?
అక్కడ ఏమైనా చేయొచ్చు కదా, వాటి కోసం దాని ప్రిమిసెస్ అది బంజర్ దొడ్డి.
Distress damage fees అంటారు. Suppose if somebody's cattle grazed in your land, you can have every right to retain it till you realize the damaged amount from the owner of the cattle. But the owner cannot go from time to time to the other places. So they will tie the cattle in the Banjar Doddi. Banjar Doddi in English name analandi. I think it is a pond or pound. That is the meaning. Let me check it. Pond or pound. He kept the. I will tell you, no. The stray cattle will be tied in the pond and go down. Pond. Let us see. Pond or pound. Let us see that. Ponds. I think the ponds. Yeah, that is the meaning of it. Stray cattle will be pond. But anyway, that is a cattle. Cattle will be in the ponds. That is where they can be made it out. That run by the which one? Ever run this currently Banjar Doddi 3-tier system lo? Village. Not municipality. What is the 3-tier system in the village? Panchayat. Are you following me?
Gram Panchayat.
Yes, sir. గ్రామ పంచాయత్ సార్.
గ్రామ పంచాయతీ మరి చెప్తలేరేంటండి? So here the idea is to force the owner of the cattle chattel to pay the compensation. After the compensation has been paid, the chattel is to be returned. Any chattel or animal or inanimate can be detained. The thing seized, therefore, maybe cricket ball కూడా వచ్చిందనుకోండి పెట్టేయచ్చు దాంట్లో. ఫుట్బాల్, కౌ, హార్స్, ఇవన్నీ రైల్వే ఇంజన్ ఆల్సో. You can retain it till you realize what are the damaged amount from the owner of the property. The Borden versus Roscoe, the case law, the occupier of land was held entitled to detain a pony. What is a pony? What is a pony?
Ponytail, sir. Sorry, sir. Pass on.
A baby horse is called pony. What is a male horse?
Stud.
What is a male horse?
Stud, sir.
Stallion. What is a female horse?
Passes.
మేర్. ఇవన్నీ చెప్పానండి. ఇప్పుడు ఇక్కడ జెన్నికి వర్సెస్ రెండాల్ కేసులా, బర్నార్డ్ వర్సెస్ హగ్గీస్ కేసులా, when I was making the distinction between the contract and the tort, అక్కడ చెప్పాను ఇది. పోనీ ఈజ్ ఏ బేబీ హార్స్ కాల్ పోనీ. అందులో ఫిమేల్ పోనీ అయితే ఫిల్లీ అవుతుంది, మేల్ పోనీ అయితే కోల్ట్ అవుతుంది అని చెప్పాను అక్కడ. సార్ మేము నిన్న తిన్న అన్నమే మాకు తెలియదు, కూర ఏం తిన్నాం అనేది మీరేమో ఎప్పుడో చెప్పింది ఇప్పుడు అడుగుతారేంటి సార్? ట్రై టు షార్పెన్ యువర్ బ్రెయిన్. దట్ ఈస్ వెరీ మచ్ ఇంపార్టెంట్ ఫ్యాక్టర్. బికాస్ నో టాట్లా,
No case law, no tort law.
సో హియర్ పోనీ విచ్ ఈస్ ఆఫ్టర్ ట్రెస్పాసింగ్ అండ్ కిక్డ్ ద ఫిల్లీ. ఈ ఫిల్లీ అని చెప్పాను ఇక్కడ చూడండి. ఫిల్లీ అంటే ఎవరు? ఫిల్లీ అంటే ఎవరు?
తెలియదు
Female
సార్.
pony. Female pony is filly and male pony is colt, C-O-L-T, colt. So this pony which is after trespassing had kicked his filly, అంటే అది మేల్ కాబట్టి ఇది kicked the filly, అది colt filly ని kick చేసింది. Until a compensation for the damage done was paid, he is not supposed to release the pony. The right is available only if the object is the question is unlawful. There can be a certain land if therefore a bull ఎవరిని అంటారండి?
Bull is the pass on, sir.
అన్కాస్ట్రేటెడ్. అది టెస్టికల్ని తీయరు దాన్ని, అది బ్రీడింగ్ పెడతారు ఈ బుల్ని. ఎవరైతే కాస్ట్రేటెడ్ టెస్టికల్స్ అవుతాయో దాన్ని ఆక్స్ అంటారు, ఎద్దు అవుతుంది అది. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
దట్ ఈస్ కాల్డ్ డ్రాఫ్ట్ యానిమల్స్ అంటారు దాన్ని. ఏది బండిని దోయడాను. బుల్ బండిని దోయేదు, ఎద్దు దోస్తుంది, బండిని నడుపుతుంది. సో the bull is small in the weight, but the ox is very heavy in the weight. So that a draft animal అంటారు. Draft, DRAFT, draft animal means pulling. We can make it the plowing, but the bulls are not for the plowing. It is only for the breeding purpose. So being a bull which is a being conducted carefully through a street, enters a shop through an open door, there is no trespass. Because the seizure in respect of animal, we cannot make it. The animal doesn't have the hypothalamus. When you open the door, naturally the animal will enter. Are you following me?
Yes, sir.
Yes,
So there is no right to follow the things after it is gone out of the horse premises, recover them from the owner. Of course, if any other thing would be there, because the bulls are not kept it, because bulls are reared for the breeding purposes, and hence nobody would make it is a bull is a trespasser. Because if the cow is there, the bull will definitely come because of the breeding. Are you following me?
Yes, sir.
yes, sir.
So what are the damages here? The claim for the damages in order to recover the financial loss suffered as the result of the infringement may be made, or alternately nominal damages, or any damages are awarded. If the damages are not awarded over there, then equitable remedy is injunction. Injunction will be awarded over there, because so that you would not make the next time trespass. The injunction is another remedy in some. Do you know what are the type of the injunctions? Do you know what are the type of the injunctions?
Yes, sir.
What are they?
IV అండ్ ఇంట్రావెనస్ అంటారు ఒకటేమో తొట్టికి ఇస్తారు సార్, దాన్ని ఆయిల్ ఇంజెక్షన్స్ అంటారు. ఒకటి చేయికి
కోర్టులో ఇస్తారండి, కోర్టుకి ఇంజెక్షన్ ఇస్తారు. ఇది ఏది చేతికి ఇచ్చేది కాదు, తొడవకి ఇచ్చేది కాదు, నడువుకి ఇచ్చేది కాదు.
మరి మీరు ఇంజెక్షన్ అంటే అది చెప్పిన సార్. ఓకే సార్.
These injunctions are given by the court order: permanent injunction, temporary injunction, interlocutory injunction, perpetual injunction, prohibitory injunction, mandatory injunction, mesne private injunction, Minerva injunction. ఇన్ని ఇంజక్షన్స్ ఉంటాయండి. మీరు మాస్టర్ చదివితే ఇవన్నీ చదవాలా, ఇక్కడ ఎల్ఎల్బి అవసరం లేదులేండి. 3 చదివితే చాలు. ఇవి టెంపరీ ఇంజంక్షన్ అండ్ పర్మనెంట్ ఇంజంక్షన్ ఆర్ పర్పెచువల్ ఇంజంక్షన్. ఇట్స్ ఎనఫ్. Okay, these are all the injunctions are the remedy. Is there another remedy would be given over there? So that animus denotes the possessor intention. The injunctions will be given. Then the defenses are there. The defendant had a better title than the plaintiff. And law of prescription. If you enjoy the premises for the more than 20 years, then you are the owner of the property. So these are the defenses would be there. For a finder of the goods is the owner of the goods. Still the owner will be traced out. So note, the landlord does not need to prove his title, but just and the tenancy. The licensee cannot dispute the title of the person who licensed them. There is no conflict of opinion between the high courts whether the complainant is the suit for the possession of the immovable property. Generally, the common law in the possession is a 99% ownership. అరే నా పెళ్ళాం ఉంటాను కదా, మనం నీ పెళ్ళాం అయితే నా దగ్గర ఎందుకు ఉంటుందిరా అన్నారా అండి? అది ఫాలోయింగ్ మీ?
Yes, sir. Absolutely.
Yes, that is నా పెన్ను అంటే నీ దగ్గర ఉండాలి, నా దగ్గర ఎందుకు ఉంటుంది అది? Because if you are lending him, you are having every right to take back your property. So conclusion, what is there? So after the researcher made it, the tort trespass would be there to segregate. There is a criminal trespass and civil trespass to the land. Criminal trespass with intention to steal. Civil trespass with no intention but forcefully entered in the premises. So these are the things are there for the trespass. A tort of trespass can be continuing in nature. When if you remain there in the premises, then you will become a trespasser. After first show also you are staying there to enjoy the second show, then you are become a trespasser. That is a continuing trespass, that is. So a person grows a tree on his land and the branches come into the defendant land, then it can be said that it is a continuing trespass until the time it is severed. Then it becomes a nuisance till it is removed over there. So there we can be having the abatement of the nuisance. Or if suppose somebody is constructed a house and which is obstruct to your vision, obstruct to your air, obstruct to your the light which you enjoyed more than 20 years, then the law of easement will come into the picture. So you can ask him to not to construct more than what you are constructed here, because he cannot enjoy the light, he cannot enjoy the air. So that is also easement also will come into the picture. So there are many remedies available from the fine form, from the injunction form, from the specific performance form, from the damages form. So these are all the things are coming to the picture where it can be available to you. So this is in general. It is a trespass to
Land.
Trespass to land. So if you happen to see the syllabus, we have, I'm showing you. See, this is the where we are now. Where we are now, nervous shock is a trespass, the immovable property, this is over. Not affecting the immovable property. That is trespass to land. Later on they made the nuisance, but let us see that part relating to the movable property. Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be.
Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga
सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।
जय हिंद।